Hello, Attorney Andrew Bethel of Bethel Law, where we teach you about estate planning, finances, real estate, and taxes. And it's about high time we delve deeper into real estate. Specifically, let's talk rent, rent control, and the California Tenant Protection Act of 2019, or AB 1482. Everything we talk about is applicable whether you're a tenant, landlord, or just someone interested in real estate. So let's move in, hit the like button, subscribe, share the video with someone who either rents a home or owns a rental home, and let's dive in. The California Tenant Protection Act of 2019, also known as Assembly Bill 1482, or simply AB 1482, added some code sections to the California Civil Code, specifically sections 1946.2, 1947.12, and 1947.13. But for the sake of this video, we're going to simply refer to everything as AB 1482, and we'll link to the text of the bill in the description below. AB 1482 was enacted to address a critical issue in California: housing affordability and stability. With rents skyrocketing, especially at the time, the state stepped in to put a cap on how much rents can increase annually and expanded protections for tenants. But what does this mean for you? Let's break down some key provisions. First up, the rent increase cap. AB 1482 says landlords can't raise rent more than 5% plus the local consumer price index. Think local inflation rate. Or 10%, whichever is lower, in a year, or really within a 12-month period. The intent is to keep rent hikes limited so as to keep housing affordable. For example, according to the Bureau of Labor Statistics, the 2023 Consumer Price Index, or CPI, for LA County advanced 3.5%. That means we add that number to 5% to get 8.5%, which is less than 10%. Thus, a landlord would only be able to increase a tenant's rent by a maximum of 8.5% going forward. I know, only. But you should know there are exceptions to this rule, so let's talk about those. Some properties are exempt, so it's crucial to know if your property falls into one of these categories. Check out section 1947.12, subsection D if you want the specifics, but I'll briefly cover the exceptions you'll likely run into. Properties subject to stricter local rent control laws. These are properties already governed by local ordinances that impose more restrictive rent control measures than AB 1482. Single-family homes and condos. An exception applies under specific ownership conditions, primarily aimed at individual owners rather than corporate entities or investment firms. But remember this one. We're going to come back to it in a big way in a moment with LLCs. Owner-occupied duplexes. The exemption is tailored for duplexes where the owner resides in one of the units, promoting owner-occupied property investments. Newly constructed properties. Properties constructed within the last 15 years are exempt, encouraging the development of new housing stock by essentially letting the investors go crazy with the rent for the first 15 years before having to rein it in. This means that properties built or first occupied after January 1st, 2005 would initially have been exempt. As time progresses, the relevant date will move accordingly. For example, a property first occupied on January 2nd, 2005 would have been exempt in 2020, but not in 2021. Conversely, a property first occupied on January 1st, 2020 would be exempt until 2035. And lastly, other specified housing types. This includes a range of housing types specifically outlined in the legislation, each with unique considerations for exemption eligibility, such as low-income housing or dormitories. Now, let's circle back to single-family homes and condos, because these are the type of investment properties that are passed down in most families, whether it be a rental property mom and dad owned, or just mom and dad's house that the kids decided to keep and rent out. Single-family homes are a common investment vehicle as they are often inherited. They're relatively easy to purchase when compared to something like an apartment or a do, tri, or quadplex, and even though real estate is a relatively illiquid investment vehicle, it's easier to offload a single-family house than a multi-family one. With that, in order for a single-family home or condo to qualify for exemption from the rent control provisions under AB 1482, we need to look at who the owner of that housing unit is. If the owner is one of the following, then it's not exempt from AB 1482's rent increase cap, meaning the rent increase is capped at either 5% plus local CPI or 10%, whichever is lower. Again, to be exempt, the owner must not be a real estate investment trust, a REIT, as defined in Section 856 of the Internal Revenue Code, which is all of this and way outside the scope of this video and something we'll cover later. The owner cannot be a corporation, and the owner cannot be a limited liability company in which at least one member is a corporation. But did you catch that? AB 1482 doesn't blanket say the owner must be a person. It specifies the specific ownership structures that would subject the single-family home or condo to the rent increase cap. Those being only a REIT, a corporation, and an LLC in which one member, meaning owner, is a corporation, not all LLCs. Meaning, you can have that rental property in an LLC, enjoy the limited liability of the structure, elect to be taxed as a corporation, assign your interest in the LLC to your revocable living trust so as to avoid probate, and so long as there's not a C or S corp in the mix, you're exempt from the rent increase cap imposed by AB 1482. Of course, if there are other stricter regulations either at the city or county level, then you'll need to take that into account as well. Now, with all that in mind, swimming around in your head, remember that landlords must also follow specific notice requirements for rent increases. Depending on the increased amount, the notice period varies. It's about ensuring tenants have fair warning. For existing tenants, a proper AB 1482 notice must be served, and specific forms are required to indicate the exemption or subjugation of the property to AB 1482. Rent increases over 10% require a 90-day notice if the property is exempt from the rent increase rules. For landlords, AB 1482 means adapting to new operational realities. For tenants, it offers protection, but also requires vigilance to ensure these rights are respected. But this is where I pass it off to you. How do you feel about these regulations? Do you think LLCs should have been included in the rent increase caps? Did you even know that LLCs weren't included? Let me know in the comments below. Be sure to like and subscribe. Send me your questions or a topic you want me to cover. I'm Attorney Andrew Bethel, and I'll see you next time.